So why don't you, let's say we'd like to wrap this up in no more than 15 minutes between you and Dylan. So to give us the highlights of what the House has done and I'm guessing from my reading of the floor amendments that they'll both pass. So if you can, that needs to be incorporated in the presentation.
Yeah, what do the floor amendments do? So that would be useful.
But let's go with what second reading did first.
So good morning, Dave Hall, Legislative Council. I say half of this bill easily is Ellen's, so I definitely want to defer to her on the tax credit pieces and downtown pieces. So I sent the committee a document that the House Senate comparison.
Oh, damn, I don't have my computer. I can,
You wanna go get it?
And if you want, I mean, I can.
did you send it to Scott? Maybe Scott could have Tony print it out.
Scott, you got it?
Is that good enough?
Oh, that's great, Scott. Thanks. If you wouldn't mind scrolling yellow to yellow here, we'll just, so
Okay.
the sections 1 through 6 are what were in the bill, they took out.
So they took out first-time home buyers?
Oh, Scott, can you go back up just and pause on line 8 there? There we go.
Got it.
Yeah, Ellen Chagowski, Office of Legislative Counsel.
Yeah, absolutely work together.
Those were the downtown, the NDA changes to the neighborhood development program, and all of those sections ended up in S234.
Oh, right.
Okay.
Yeah, the municipal
That
zoning.
expands- One of the things it does is expands that program to allow for neighborhood development areas to parking credits, right?
No, that's later in the bill. That was the sections that raised the cap on the number of priority housing projects
Okay.
exempt from Act 250. It expanded the neighborhood development areas into the flood hazard areas,
Right.
and required that towns in their municipal bylaws adopt the flood hazard area bylaws. So that was the municipal zoning changes.
The 1 through 6.
Yes,
That's all our Act 250 stuff. too.
and municipal zoning. Yes, and it's in S234.
So Scott, if you wouldn't mind dropping down now to section 2 on page 2. So on the first generation home buyer piece, you know, the underlying is to add to that section of law the ability to reserve funding and provide grants to first-time home buyers who are also first-generation home buyers. The addition is here on the implementation component, so directing VHFA to adopt guidelines, and A, B, supplying a definition for a first-generation home buyer. Mara has suggested it comes directly from federal proposed legislation. It's not enacted. Subsection C, the outreach component to communities of Vermonters who have historically suffered housing discrimination.
Who has control over that?
Oh, sorry, Scott, yeah.
So this definition of first time is there.
Yeah, and then D is the money, and right now that is in flux. It's currently $1 million from what was the appropriated amount to DHCD, and it is ARPA, but there's a question on whether they're going to have to cut that to pay for the land access board, and that's still so that's $200,000 that may or may not be taken from this on the House side.
So are you saying that today, before they send the bill over, they may tinker with this? And
The land access.
and did we say, we enabled EHFA out of their existing bottom line to give grants to first generation homebuyers? We didn't mandate any particular amount.
Right. You just said that they're allowed to use money available in the DPA for grants. And then, so,
And I think you mentioned VH. Whenever I hear VHCV, this is my hearing. I'm not sure if people are saying DHCV or VHCV.
yeah,
So in this case, it was DHCV. there.
Yes.
the department,
The Department of Housing
Yeah.
and Community Development.
right. So, Scott, if you wouldn't mind scrolling us down. So, manufactured home relocation incentives. So the House has reduced this by $1 million to pay for the a later section in the bill that originated here, but they have modified. So note that this used to be 3 million and these used to be 1 million each. So they took $1 million from here.
Okay. Is it ARPA or?
I think it is. Yep, this is ARPA funding. So Scott, can you keep going down to the next section, line 9, and highlights? There we go. So this is the place where they've moved the money. So you remember you had this as the combination of commercial conversions, employer housing, and neighborhood development partnership. So this has been modified to just be the community partnership.
I'm sorry.
Sorry.
Hold on 1 second. I get rid of this nasty bee guy. Yeah.
I don't know what they've done to make it, but. It's sweet, sweet. Look at all of us. You guys are just as you are tired, if not more tired than we are. Manufactured homes for this mission.
So this community partnership for neighborhood development is the sole subject of this section now. So at the top, at the lead of this program would be the department, but it also would work in tandem with this Housing Equity Council that comprises all the groups, and it's very similar to what you had in the third part of your language. In the purpose, I don't know if you recall, this proposal is from the administration, but it's to do a pilot neighborhood and, basically do a demonstration of how we can have smart growth development, infrastructure, neighborhood development.
Sorry, is that this Housing Equity Council?
Well, so that is the coalition of all these many different groups that will be reviewing the pilot proposals and, sort of brainstorming how this thing could work. It is scaled back. It used to be 3 pilot neighborhood development projects. There's money in this now for 1, and it's the way you had it. You had said that VHCB could use up to $5 million of the funds available to it to do any one of these 3 things. And they have changed that to say appropriation of 1 million ARPA dollars, department leading the charge along with this Housing Equity Council, do 1 demonstration pilot project, and tell us how this is going to work. So you'll see, Scott, if you wouldn't mind going down to.
So the department is sort of leading the troops on this.
Yeah, page 8, line 12. subsection F. So there's the live appropriation of $1 million to DHCD, and they can use up to 100,000 for administrative expenses. So plenty of words, but that's the gist of it.
And did you have any discussions on the ARPA versus general fund question? Sound like a recovery purpose for every year, but,
Well,
No.
I think as long as there's the nexus to affordable housing development, it's sort of got the all clear from the powers that be. So the next bit, Scott, if you wouldn't mind going down to line 6, the municipal modernization bylaw grant bylaw.
Just one final question on that.
Yep.
So this is the only role for this council, so-called council, is to work on this program?
Yeah, I mean, the council is a name assigned to all of the stakeholders working together who will review the proposals.
So, and why is this council needed when we have DHCD working with DHCD? I mean, I don't get it. We have some of the most equitable eyes looking at this.
No, it's
That's
basically the
not the
same.
reason why.
I think it's basically the same thing, except it's given a name. It's all the same people who work on it.
Over at the beginning. So,
At least it's not a study.
So the bylaw modernization grant.
and sorry, how many years are we given to do this pilot?
It's through 26, it's through the ARPA period, right?
Yeah, so for the next 2.5 years.
But the money needs to be obligated
By the
for spend.
24.
Okay,
Scott, can you switch to my amendment? So, sections 10 through 12 were the municipal bylaw modernization grants. That entire program, was put into S234. It's still there. And there have been almost no changes to it, very minimal. It's still $650,000 of this year's current appropriation is going to the bylaw modernization grants.
650.
and where did they land in terms of where the money's coming from? I think in one version, the planners getting out of their money, another one was the municipalities was coming out of their money. This is not, it's not freestanding district money, it's out of another appropriation, right?
So nothing has changed from how it's been drafted. It is currently that it's part of the municipal allocation of the municipal and regional planning fund. However, currently there is $650,000 of the current municipal regional planning fund appropriation is for the bylaw modernization grants. So of the $800,000 that's being appropriated to the municipal allocation, $650,000, up to $650,000 can be spent on the bylaw modernization grants this year.
How does that money work? I would assume some people who would otherwise get the $850,000 may have some concern that almost all of it is now going for bylaw. Would they not be able?
So the other part, I'm sorry, I have to go in a minute, and also we're running up against time here. So the current municipal allocation is already a grant program for bylaws. But it's for basic municipal planning, including just town plans, building a town plan, the meetings associated and development costs for a town plan and bylaw development. And so they are very similar. So it's already there isn't a standing allocation from that to anyone specific. It's a grant program annually already.
Because from ACCD and they award grants to the municipalities.
Yes. Yes.
So you say you have to go?
Yes.
Okay.
So I did just want to tell you my only other change is, so the downtown and village center tax credit program, Ways and Means worked on it. They only made one change. It's on the screen. It's section 6. So intact in this bill is that the downtown tax credit program is being expanded to neighborhood development areas, and the flood mitigation tax credit is still in there. So that's the new part that's still in there. The only change they made is that you had proposed a 5-year sunset. Ways and Means has decided to make it permanent with a caveat. So the caveat is this new language in section 6, starting on July 1, 2025, under this subchapter, no new tax credit may be allocated to neighborhood development areas unless specific funds have been appropriated for that purpose. So in S11, which I think you've already received, there is specific funding up to $2 million in the next 2 years can go to NDA tax credits. And so that's for this year and next year, but then beginning in 2025, the NDAs can only receive tax credits if
we appropriate. I mean, yeah.
Is there any reason that we can see that we would either move this language to S11 or move the money from S11 into this bill?
That's above my pay grade. I mean, I think if you put them together, that would make sense, but I don't have an opinion.
So what's our total now? I'm sort of lost all the monies here. Our total now for downtown tax credits is
S11 appropriates $2.7 million to be used additionally on top of the $3 million.
So we're now at
5.7.
5.7 with $1 million carve out for NDAs.
2 million in the next 2 years. So approximately. Ways and Means.
Actually, right. So that in effect just takes us down to the same amount for the downtown tax credits.
Well, 2 million out of the 2.7. Yeah.
So it actually only increases the downtown tax credits by $750,000.
Yes, and it only does so temporarily. It's not a permanent raise on the cap.
It's also up to, I don't think they're going to use the whole million.
I don't know if that's.
Do we allow the downtown tax credits to be clawed back? Because they're always oversubscribed. We allow that money to be clawed back if they're not being used by the neighborhood development areas, given how few neighborhood development areas there are at the moment.
Yes, it's up to 1 million, and yes, there is a recapture period for the entire program, but this would apply as well. And that's why it's actually not specific in S11. It just says up to 2 million in the 2-year period. That was in case there was a ramp up in the first year and there wasn't significant uptake.
Yeah, well, let's let Ellen go. We have to decide between the two versions. They do the same thing, but I think in terms of budget.
Wastewater connection completely gone, and ADU for section 21 completely gone.
1.35 each year.
In the ADU section.
1.35.
And they're aware of
Plus the 2.7 goes against us.
The 2.7 votes against us.
Thank you, Ellen.
Would you mind switching back the screen to my amendment and going to page 15? So Ellen says you're aware of the wastewater connection permit stuff, and that the ADU section 21 is in that other bill now, 230. So
It's in 210 as we offered it, right? Oh, I see. This is stuff like parking and other stuff.
Right.
This is not.
yeah, no, this is the land use piece, not the program language.
That also made it to 234 as far as.
Yeah.
So, sorry, sections 19 through 20 are in 230 are cut altogether.
They are nowhere to be found.
They're nowhere to be found. That's why we're in conference on 101.
We're trying to.
Trying to get into conference on 101. And then the accessory dwelling units are in 210.
No,
Where are they?
they're in 234, but I can't remember exactly what they are. I think there was a lot of parking. It's probably unfair to estimate.
Oh, so these are the more modest ADU measures. This isn't the bulk of our ADU work was in 210.
Exactly. This is sort of
Okay, I'm
the land, this is sort of the land use stuff like parking.
Right, I remember. Yep. Okay.
So, the missing middle, Scott, if you wouldn't mind just kind of slowly scrolling down through till we get to some yellow. It's still 5 million and 10 million. Most of the terms are the same. I mean, they changed so if you could pause here, they changed it from home buyer to affordability subsidy, and for the benefit of the home buyer, to put the emphasis on the fact that it's really, it's an affordability subsidy that comes after the developer subsidy. The line 6, to the extent the home value has risen, is to hold harmless, in case home value goes down. If you could scroll, Scott. And then in B here, slight change in language, cross-reference the housing subsidy covenant provision of 20 VSA 610 that preserves the affordability of the home for a period of 99 years or longer. Agency shall allocate not less than 33% of the funds available for the program to projects that include a housing subsidy covenant consistent with 2B.
Does the housing subsidy covenants, in addition to affecting the price of the home, does it also talk about who the home can be transferred in terms of income? You have Jen here with us.
I actually don't know the answer to that. I'd have to look that
Jen,
up.
would you be able to answer that? When you do covenants, do you also have those covenants that the person has to be low income?
When the Vermont Housing, John Holler, VHCD, when the Vermont Housing Conservation Board does a housing subsidy covenant, we do talk about the income of the person. But
It's
this
just
is
refers-
specific to the affordability of the home, not the resident, the way it's drafted here.
Okay, and David, I don't see the language, but I thought we had some language that on both fronts, we wanted there to go to people below a certain AMI.
I think that's further up, isn't it? I don't.
Let's go ahead, Jen.
This is not part of VHCB's proposal, but I do recall discussion on the House side that there was not going to be a mechanism under this program for them to keep track of what the income of people was over time. We weren't going to be able to income certify. It wasn't going to fit into the program model as they designed it. So the House accepted just affecting the price of the home versus the income of the buyer.
But at least for the housing subsidy covenants, even though it might not say that it's 610, 27 VSA 610, I don't know what it says, but if it has anything about income eligibility for the next home buyer, but even if it doesn't, the people who operate these housing subsidy covenants have mechanisms on which to screen potential home buyers. So I'm wondering why we couldn't at least apply that requirement to the third, the 33% that are doing the traditional share equity model.
It's probably a question best for Mary Vermont.
Yeah. I hear her explain all of this, and it makes perfect sense about how the future of those mechanisms work out. And this does, it does limit it to income eligible home buyers at 120 of AMI to begin with as part of this program.
Right.
Oh, they didn't change that?
No, that's still.
Good.
That's still in subdivision B2, income eligible home buyers of Vermont households with a annual income not to exceed 120% of AMI. So you have to be an income eligible home buyer, when you're going through this process for the affordability subsidy, et cetera. But I think the part that Jen's talking about is, down the road, there's really no way they can manage. There's going to be some drift. So, whether the covenant could possibly limit, future exchanges, I don't know. I think we might need to hear from Chris Donald on that.
Okay, and could you pull up the section that you're talking about AMI?
Yeah, Scott, do you mind scrolling up to B2? So that's, I don't know where that is. It's all right. Page let's see, 16.
And that is the way this is written out. Does that subset, does the term income eligible buyer apply to shared equity plus the other two-phase program or to the whole program?
It's the whole thing. It says in C that the agency shall use funds to provide subsidies for new construction or acquisition, substantial rehab of affordable owner-occupied housing for purchased by income-eligible home buyers.
I like the fact that it's still in there. I understand there's an enforceability problem, but I think to the extent that you're signing a contract, you know, in terms of getting this money or covenant on the house, you could say that, and whether it gets enforced or not, we'll know this down the road. Certainly, a lot of people know that they're subject to that and will just follow it voluntarily. So I'm glad it's still there. Okay. Yep. So,
So, I mean, I just, and I think it's fine because I think it will be loose in terms of enforcement. But I just, like, with the first, with the shared equity home ownership program, what's nice is people's income grows while they're there. And obviously then money gets clawed back when they leave. And we're not necessarily able to solve for that, but I want to make sure we say out loud that the point is for people's income to grow when they
well, this
become.
doesn't affect the people in the
This
home.
is for the people who can buy it.
This is who can buy it, okay,
This is the perspective
okay.
for the future.
Home buyer, okay, I don't have my glasses on, so I asked for a paper copy. Not it, I'm not to go there. Okay,
Keep going.
We are slide down slowly. Page 19, Scott, line 4, just extending the reporting date out, so it'll run through the ARPA period, and then that report would be through the following January. So that's it there. The residential construction contractors language is mostly the same. You know, it's still $10 million, $10,000 for the threshold in both places. There was one change on page 25, lines 18, 19. This is just about the amount of insurance, and basically they just heard that the minimum amount you're gonna get in the market is this. So it's an increase.
So they heard that that's the minimum that's sold on the market.
Right. So
We don't really need to change it. It's just.
right. It could have stayed the same, but they just wanted it to be reflective of the information you received. And then, let's see, there was on page 30, the AG cap position and appropriation. It's really just minor wording changes. It's still the same. It's still a position. It's still to help mediate disputes.
I heard something that, something that sort of allows or highlights the fact that the contractor can also complain versus the consumer. Did that make it in or?
Yeah, I mean, there was a lot of discussion about that. And Charity Clark came and testified. So you'll see, like, her whole point was in A1, line 9 here, when they say assisting with consumer complaints, I don't love the wording, because her intent is that it's consumer in the context of the Consumer Protection Act. So sometimes that can be a business sometimes usually it's an individual, but a business can be a business consumer that's protected under the act. Their point was that, they would help with the education outreach and mediation to both contractors and consumers. They will help try to resolve problems as long as it is a consumer complaint. They're not going to get involved if it's a business that didn't get paid. That's not what this is about. So,
This is, we've moved down to open contract. Yeah. Thanks.
Okay, let's see. So starting on page 31 of my document, you've got some stuff that Damien worked on relating to housing discrimination. I don't know if are you with us right now, Damien?
Yes, he is.
Yes, I am.
Do you want to address your
Yep.
unfair housing practice language?
Sure, I'd be happy to. Good morning. For the record, Damian Leonard, Legislative Counsel. So Section 19 brings us into the Fair Housing and Public Accommodations Act. If we can scroll down to subsection C, Scott. So what this does is it adds in intent language, that it's the intent of the General Assembly that the provisions of this chapter will be construed liberally to accomplish its remedial purpose, and any exceptions and exemptions to the provisions of this chapter shall be construed narrowly in order to maximize deterrence of discriminatory behavior. This is essentially a statement of existing case law precedent. This is a remedial law designed to protect individuals from discrimination. So our courts and the federal courts have always construed these laws liberally. But the House is adding this language as part of sort of codifying its intent that continue into the future. But it will not actually change the existing interpretation of the law. It'll simply be a codified reminder in the future that it is the intent that it continue to be construed liberally to protect against discrimination. Section 20, as we scroll down here, is in the unfair housing practices. The first change here on line 12 is just a style change to be really clear about what we're referring to. So there were some questions here that were raised in testimony about whether these protections related only to the sale or rental of a dwelling or other real estate, or just to, in general, the provision of services or facilities in connection with a dwelling or other real estate. And this language here reflects the case law again, where consistently under both federal and state law, this second clause here in the provision of services or facilities in connection has always been interpreted as being with a dwelling or other real estate in general. So to give you an example of this, this would apply to, for example, a condominium that has a discriminatory practice or provides services to the residents in a discriminatory manner, rather than just at the point where someone buys their condominium. Does that make sense to the committee? I'm going to go with yes, because I can barely see you guys in the little thumbnail picture. The next addition here is adding a definition of what the term harass means. If we can scroll down, Scott. So it means to engage in unwelcome conduct that detracts from, undermines, or interferes with a person's terms, conditions, privileges, or protections in the sale or rental of a dwelling or other real estate, or in the provision of services or facilities in connection with a dwelling or other real estate, because of the person's race, sex, sexual orientation, gender identity, age, marital status, religious creed, color, national origin, or disability, or because the person intends to occupy a dwelling with one or more minor children, or because the person is a recipient of public assistance, or a victim of abuse, sexual assault, or stalking. This is again essentially a restatement of the existing law, but the Human Rights Commission brought this language to the House, asking that it be included to clarify the existing law, because there was a lack of clarity, and there have been some inconsistent court decisions about what harass means. And I don't know that the court decisions have necessarily been in Vermont, but there was a concern on the part of the Human Rights Commission that to the extent that we often use court decisions from other states, because we have, because we're such a small state, we often don't have judicial precedent that's directly on point, that we clarify exactly what we mean by harass. And so that's the reason for the addition of this language. The next section here is a significant change from existing law. So this is probably from lines 8 to 11 is the most important piece of this section and the most significant change. So notwithstanding any judicial precedent to the contrary, harassing conduct need not be severe or pervasive to be unlawful pursuant to the provisions of this section. The current law requires that in order to be unlawful, discriminatory harassment has to be either severe or pervasive to be unlawful, which means that you can have conduct which is discriminatory on its face, but because it doesn't rise to what the court deems to be a level where it's severe, or it doesn't occur long enough or consistently enough to be what the court deems to be pervasive, the court finds that it's not actually unlawful. And so it limits people's ability to actually enforce the law against discrimination. So our Human Rights Commission again asked us to make this change to enable more individuals who experience discriminatory treatment to bring claims under the fair housing provisions of our Fair Housing and Public Accommodations Act.
It's just this whole change in how you interpret harassment only applies to housing situations.
Yeah, so the original version of this was in H329, and it would have extended it to all fair housing and public accommodations. However, the public accommodations portion was pulled out because it created a conflict with the harassment law for schools that we adopted recently. The schools have, under Title 16, there's a separate harassment law, which does employ the severe or pervasive standard. But then your civil suit, after you've exhausted your administrative options for resolution, is through the Fair Housing and Public Accommodations Act. So there was a concern that the schools would be following the law under Title 16, and then an individual, if you could stop scrolling, please, Scott. And then an individual would bring a claim under the Fair Housing and Public Accommodations Act, and behavior that is not unlawful under Title 16 would be unlawful under Title 9. And then the schools would essentially be forced to comply or held accountable for not complying with a law that they're not required to comply with. So it was, because that required a lot more testimony and a lot more thinking about what the best solution is, they pulled out the public accommodations piece and just left the focus on fair housing, which had not generated controversial testimony in the House.
A fair amount of discretion in terms of the penalties associated with this. I mean, so if you had a relatively minor instance of harassment that's now considered unlawful harassment, that will entitle you to triple damages or
Yeah, so the the way it works is, let me just pull up the enforcement language here. So you have a couple of options. One, you can bring a charge of discrimination with the Human Rights Commission. The Human Rights Commission can then do an investigation, and they often seek to mediate the dispute and get a resolution for everyone. And then they have the option to bring an action in court. You can also bring an action for injunctive relief, so an injunction stopping the behavior, and then compensatory and punitive damages and any other appropriate relief in the Superior Court. And you may be entitled to costs and reasonable attorney's fees if you prevail. So you can get compensatory damages, which depending on the situation could be quite limited, or could be significant depending on what the nature of the discrimination was and what its impact was. Punitive damages could be more specific, but there's no sort of like treble damages provision or something like that. The court has to determine what an appropriate punitive damage would be in order to deter the behavior from occurring in the future. And that, of course, is always subject to appeal.
Would the attorney's fees be permissive, or it says may, I heard?
It is a may, so the court determines whether awarding costs and attorney's fees is appropriate if the party claiming discrimination prevails.
Okay.
And then that is essentially it under these provisions. There is a potential also for a criminal fine of up to $1,000, but that's it as the possibility for a penalty, and there's no word on who actually enforces that fine.
So is there any, was there a lot of any controversy around this section that we might want to hear from other witnesses?
The House, in hearing these provisions, the largest controversy and the most testimony in the House was on the employment provisions. There was a lot of involvement on the employment provisions with both employer side and employee side attorneys, representatives of business groups, and so forth.
Sorry, David, that was in the bill itself in H329, right?
Yeah, the fair housing and public accommodations language only seemed to generate attention and controversy on the public accommodations provisions and how they would impact our public schools.
Those are taken out.
And those have been taken out. And then the language in here has been trimmed down to reflect what the final compromise in the employment sections was. So it's consistent with the employment sections, except it's tailored to the fair housing law, which has a different list of protected categories.
You said the employment stuff was controversial, didn't make it. Right?
So the employment stuff did make it in response to the testimony. The original bill generated controversy in response to the testimony. They trimmed down the provisions, and that made it was poised to make it out of committee when the public accommodations issue was raised the day before crossover. And so the bill got pulled back in and didn't make crossover.
But it did get passed out of committee though, right?
I've got to take a look to see if the committee finally voted it out or if it got held back because of that issue.
That's the provision that's not on 320, right?
Yeah, the
That's what they're
bill did not get a final vote out of committee, and it was because it was scheduled to vote out, but because of the public accommodations issue, it did not get that vote because they didn't have time to resolve that issue. The resolution of that issue is reflected in the language in front of you, which is take out the public accommodations entirely and focus on fair housing.
Okay, anything more on this bill?
So the guidance here in A, B, C, this is a reflection of basically a compilation of case law guidance on how to make these determinations. And again, this reflects that there's been inconsistency at the courts between the state and federal levels and in various states. And so this would just sort of set out Vermont's understanding of how to interpret these cases. And this did not generate much controversy.
Hey, Damien,
yeah.
I would really like to vote out the workers' comp surcharge in the next 3 minutes. Is there more?
Sure.
Is there more we need to talk about?
Yep. Scott, can we scroll down? There is another section in here. So otherwise we can stop this and go to the workers' comp surcharge if you want to do that.
Yeah, let's do that.
And we have.
Okay. Because there's several more sections in this bill.
Yeah, there's.
Okay. We'll finish up on this.
Okay.
So if we can.
So
Uh,
let me pull up the workers' comp surcharge, and Scott, if you make me a co-host, I can share that.
While he's doing that, I'll tell you, this is something we do every year. It funds the administration of the workers' comp division. It's a surtax on workers' comp insurance premiums. It's calculated primarily by how much money they need and the projected volume of workers' comp insurance. And it's basically ministerial. And each year I try and get rid of this coming to the legislature, but never seem to be able to get
Right.
to closure. So, but let's just, it's one paragraph. I want to vote this because it has to go to finance.
Okay.
Yeah. So the language here is boilerplate. The only change this year is that the rate, which I just highlighted in the middle of the screen for you, was 1.4% last year. And they're projecting that it needs to be 1.5% this year. My understanding is that this is a combination of costs related to modernization needs in the program and reductions in the amount of direct written premiums for workers' comp. So the reductions in direct written premiums is a good thing because it means costs for workers' comp are going down in the state. And then the modernization costs, my recollection is that those are part of long planned projects. And they're just making sure that they have enough funds with the diminishing rates of premiums to ensure they can pay for them. I'm sorry.
Was there any opposition or testimony against this at all?
No.
Are we ready to vote this?
So what bill is this in? I don't see.
It's all bill.
It's H559. It's its own bill. It was referred to right around crossover.
I would move that we pass H559 out favorably.
Thank you. Have a motion. Any discussion?
Do you want to hold open the vote? or-
No, that's fine.
Okay.
All in favor, say aye.
Aye. And we could
We can hold the vote open.
get Randy and Becca's.
I mean, you could say unanimously. I don't know if there'd be questions.
We'll be good. Thank you, Damien. We'll see you upstairs.
Yeah, I'll see you there in a minute.
So, okay, so we are holding it open if I see.
Yeah,
I
would
think
be
we just voted 3-0.
Okay.
And then we'll.
3-0
ask if they
too.
wanna add
Okay,
their votes, so I'll bring it up. I'll be the reporter.
okay,
And,
sounds good.
Okay. Randy, would you like to add your vote to the 3-0 vote you just took 30 seconds ago on the workers' comp insurance surtax, going from 1.4 to 1.5. Fund the department. We do it every year. It's boilerplate, it's ministerial. It's coming to the legislature.
Well,
We have it.
in terms of raising it by, from
0.1%.
a 10%, is that a fee increase or a tax
It
increase?
has to go to finance. So, you know,
You'll get the second bite of the discussion.
it's viewed as a surtax on premiums that employers pay. We do this, it's a 1-paragraph thing. We do it every year. Basically, they look at the cost of administration of the workers' comp program. And they look at the amount of premiums they're taking in expected. They do the math. They come up with a surtax. It's been no opposition
How
to
much money involved total raise total?
0.1%. I think the premiums are running about 200 million. So 0.1% would be $20,000 total.
Program for workers' compensation or 1.5.
If you want to abstain, that's fine. If you could hear it in finance. I just want to get the bill.
No, I understand. I just want to read it. Self-insured workers' compensation.
Board, and they've done a lot of stuff.
Okay. Then I can open, but I.
And
Yeah,
this
yeah, I
is, this
know
is,
where we're
in fact, this is a,
But it's,
For all intents and purposes, this is a fee, and it's adjusted a fee to cover actual costs. Is that the object?
I don't know if you call it a fee, but yes, it's designed to cover the cost of administration. So like insurance companies pay money to run their department.
Okay. Yeah, I'll go.
Okay, so it's 401.
4-0.
Let me see.
Allison, was it solely Senator White who was checking on participation in the EB5 resolution?
She was doing that to make sure the Democrats were okay with it.
Yeah, that's what I mean. I was looking for an all-set resolution, and I'd sent a couple notes to you.
Yes, and I somehow failed to send that out. I thought
Yeah.
you said we're gonna send it to all the
Well,
senators.
Jeanette said that.
She went and did it individually.
Yeah, she said she did it individually.
I think we're all set.
No, she said one person who doesn't want to do it right now.
Really?
And then one was wavering, she was gonna see him and let me know in a couple minutes, because just gotta get an answer of what we're gonna do.
Sorry, she took it over because at
No.
that moment it was on the floor.
Yeah, yeah.
And I don't know how I missed that from you, but I did.
Well,
And
it's
I
all right.
did- and I thought you were gonna send it out to all the Senate saying,
No, I didn't. The lead, caucus leaders were gonna do that.
oh, I'm sorry. I don't know how I missed that from you.